Hello everyone and welcome to today's Mondak webinar in association with Acticon, who will be discussing the major competition law developments in Turkey in 2023. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Bahadir Balki is a managing partner of Acticon and co-head of the firm's competition practice. Bahadir represents clients in investigations of the Turkish Competition Authority, ranging from cartel cases to a variety of dominance matters. He is experienced in complex mergers and also leads competition compliance programs across a range of sectors. Dr. Hanna Stakheyeva is a Ukrainian qualified lawyer, PhD, specializing in EU competition law. Hanna has worked in Belgium and Ukraine and is currently based in Turkey, where she works as an assistant professor at Boğaziçi University. Hanna is an of counsel at Acticon, focusing on competition law matters. And completing our panel is Kaan Gürer. Kaan is a counsel in Linklaters Düsseldorf Antitrust and Foreign Investment Group. He has diverse expertise in all fields of antitrust law, with a focus on investigations, compliance advice and merger control, both at EU level and in Germany, including on vertical and abuse of dominance questions. Based on his vast experience in several complex matters, he is very familiar with the structures of both the Federal Cartel Office in Germany, where he spent time during his legal training, and the European Commission. And before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. And we will endeavour to answer as many of those questions during our Q&A at the end of the presentation. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thank you, Dan. Hello and welcome, everyone. It is a wonderful opportunity for all of us to have a friendly chat on some of the important competition law developments in Turkey, as well as in the EU, and why is that important and interesting? Well, because the topics that we've chosen are actually relevant not only for Turkey, but also to other jurisdictions, and I'm sure for those jurisdictions that our audience is connected from. So on our agenda is to cover labor HR issues in competition law, merger control upgrade, I call it, so to meet the challenges posed by the digitalization, and the actual digitalization and its regulation in Turkey. So I suggest that we begin, first things first, we begin with the labor markets, a hot and rather new topic nowadays for Turkey, but that has already taken a lot of our attention. So Bahadir, the TCA, Turkish Competition Authority, has lately really been active in terms of competition law enforcement in the labor markets. What was the triggering point in the recent enforcement?
Thanks a lot, Anna. First of all, also thanks a lot to Mondak for this great platform. We are always happy to be a part of it. And Anna, Kaan, also let me thank you for being part of this Acticon events. I'm glad to have this webinar with you, great competition lawyers, but also my friends. Thanks a lot, my friends. Anna, you have a very fair point to start. What is the triggering point for this current enforcement on labor side? So the main reason in my mind is more macroeconomic and social developments. HR field is not like digital sectors. Digital sectors came into our life recently, but labor field was always there. So first pandemic, then monetary fluctuations affected labor markets significantly. They increased labor costs. They increased salary levels. They changed job descriptions and working conditions, of course, globally. So, and after all these changes, competition authorities, as a part of economic policy, keep an eye on this matter as a policy focus. Turkish Competition Authority might be one of the first authorities dealing with labor cases. And now I also see that European authorities started stepping in this matter. First, Lithuanian and Polish authorities concluded their no-poach cases related to basketball leagues. Very interesting as a basketball fan. Then Portuguese authority concluded a no-poach case for football clubs. What is wrong with sports or no-poach area? Now I have seen that the EU Commission also initiated a no-poach inquiry in food delivery, and also the French authority very recently in IT services and the technology consulting. I also noted to myself Ms. Vestager's words. She defined no-poach agreements as an indicated way to keep wages down. Also, the president of Turkish Competition Authority made a public statement on no-poach agreements and defined them as a barrier in terms of free movement of labor sources. So these are very strong messages. And considering these strong messages, we will definitely see powerful competition law enforcement in labor markets in the short run. Before the recent trend, even before this recent trend, Turkish Competition Authority was also active in labor field. The first case happened in 2005, and it was about a no-poach allegation among TV producers for not transferring actors or actresses. The Turkish Competition Authority emphasized, even at that time, in 2005, wage fixing is considered as fixing purchase prices. The authority closed the case at the end of the day, since there was no finding proving the allegations. But from time to time, until 2022, the Turkish authority dealt with labor cases. Didn't give fine to the undertakings, but always gave the message that agreements in labor fields among competitors might restrict competition. Since the beginning of 2022, we have seen notable actions. We are in now a different era. Just to briefly outline the recent enforcement, 16 hospitals were fined for wage fixing and no poaching. 27 undertakings, mostly digital platforms, were fined for no poaching. Another no poach investigation against IT and telecom sector is also very close to an end. We have also a number of ongoing investigations. On November last year, an investigation was launched into construction chemicals for alleged information exchange and no poach practices. This investigation is quite important. This investigation has its own feature since the EU Commission announced that the Turkish Competition Authority, the CMA, and the EU Commission made joint dawn raids in this investigation. In addition, the pharma sector is also under scrutiny for allegations on no poach and wage fixing. Ready-mix concrete producers are also being investigated for similar allegations. So you may see HR-related allegations in every market. It might be the most technical, most technology-related industries like digital platforms, pharma, or the most conventional industries like ready-mix concrete or construction chemicals. So I may say that labor field should be in the center of each company's compliance policy in terms of competition law.
Mm-hmm. I see. I mean, this is pretty impressive, let's say, the number of cases and investigations already that took place in Turkey. So lots of cases, but what I also understand, there are also a large number of undertakings in each investigation, like the recent one that you mentioned, right? So around 50, the recent one that I heard, around 50 undertakings were subject to the same investigation. So why is that? What is the dynamic behind this? And how about the authorities' approach to such to no poaching, let's say, or other issues in labor markets? So is it by object restriction, or does it look also into the effects? What's your feeling? What's your observations?
Indeed, you are right. The definition of being competitor is really remarkable here. In terms of technical details of no-poach investigations, imagine on the one hand, a startup game developer, and on the other end, a car manufacturer. Obviously, both are in need for computer engineers. And the main operating field is irrelevant for the labor side of competition, since a good talent can choose either of them, can choose a car manufacturer or a game developer if you are a computer engineer. So then, actually, the outcome is everyone competes with everyone in this labor market. And in terms of object-based or effect-based violation, actually, we have seen that Turkish Competition Authority adopted a strict approach towards the no-poach and the wage-fixing conducts. So far, it's rejected a number of commitment proposals from the investigated undertakings, stating that no-poach and wage-fixing falls into the hardcore restriction category. So the authority ruled that no-poach and wage-fixing are regarded as object violations and cartels. In the authority approach, no-poach and wage-fixing conduct should be assessed like buyer cartels or market-sharing practices.
Well, that's interesting and important to know, of course. How about the vertical settings? So, for example, a service provider may have the incentive to enter into a non-compete setting vis-a-vis the receiver of the service in terms of the personnel. So, is it something that can be justified or exempted in authorities' eyes?
Actually, thanks for this question, because in terms of daily operations, it might be the most important topic in terms of competition law enforcement in the labor field. Companies sign many service contracts or outsourcing agreements, and in these contracts, no-poach articles are quite common. The coverage of such articles are indeed important. First, no-poach articles in such contracts must be objectively necessary to implement a main operation. And second, it must be limited with a specific project team, project people, and the project duration. So I would say that the Turkish Competition Authority recognizes the need for a no-poach relation in a vertical setting for a healthy flow of a certain project, for a healthy flow of business. However, at the same time, the authority expects the undertakings to be very precise, about the coverage or limits of that no-poach articles in vertical settings.
I see. Well, makes sense. So how about then minimizing risks? So what should an undertaking do or do not do to minimize the risks?
First, constant targeted education at HR departments is a must. Attending HR teams meetings instead of classical competition class trainings might be more practical, in my view, and might be easier to catch the daily operations. So I suggest to attend HR teams, specifically HR teams meetings. to create a healthy compliance level in that field. Be careful while using HR jargons like off-limits, no-go, untargeted companies. Such jargons may create doubts for collusions. And be sure to provide reasons why you don't want a certain candidate. This is quite critical. Examine contracts that might contain no-poach articles, just like we discussed. Be careful about their coverage and revise if necessary. And no benchmarks with other employers on salaries, benefits, bonuses. For market research, everyone needs market research. For market research, consult with independent HR intelligence firms who give you anonymized and past data. Anna, thanks for these practical questions. I may finish my part now. As our second title, we are switching to another hot topic, merger control in technology-related markets. This is indeed a hot topic in both Turkey and the EU. We have here in Turkey a specific definition called technology undertaking exception. And giving credits to Turkish Competition Authority, this definition is very forward-looking, let me say. So we are going to listen to Kaan on how he assesses the technology undertaking definition in the Turkish merger control regime and how he evaluates the current situation, or let me say hurdle or tension in the EU based on Article 22 enforcement.
Thank you very much, Bahadir, and thanks for having me here and to provide my insights and my comparison from an EU law perspective. It appears, and thanks also for your remarks on the labor markets, it appears that the Turkish merger or the Turkish regime is really on top of things and pioneering on this field. And I would say the same as you already said with regard to merger control. Because in Turkey, we already have reforms that were introduced almost 2 years ago now, as you also mentioned, to capture a broader range of transactions involving technology companies, including different sectors such as digital platforms, software companies, fintech companies, for example, or companies in the health sector and chemical sector that also have technologies in this regard. And the thresholds were changed, especially the requirements for the local nexus were lowered. You are the expert on this, but we also see that from an outside-in perspective, of course, because the number of transactions that might be covered by the Turkish merger control regime, of course, increased by these changes. In our understanding, the Turkish Competition Authority clearly aims at killer acquisitions. I know, Bahadir, that you don't like this expression, so maybe we call them technology acquisitions, which might be the more proper way to put this. But I think killer acquisitions is what the audience knows and understands in this regard. At EU level, there have not been reforms like that, but of course, still the European Commission sees the need to also capture such sort of transactions where you have technology companies that have low threshold, low turnover in the beginning at least, even have decreasing turnover figures, no revenues at all, etc., but still are of very high value and of importance for competition. So you somehow want to capture these transactions as well. And the European Commission, in lacking reforms, is forced to use other creative methods to capture these transactions. You already mentioned one of them, which is Article 22. We will speak about that and also about other mechanisms the European Commission is using. Compared to the reforms in Turkey, at least from the outset, these provide more legal certainty. to companies, and they seem to be very modern and progressive indeed in Turkey. And without these reforms, the European Commission has taken a different approach. So even if certain transactions, like transactions involving technology companies, do not meet the traditional turnover thresholds that are laid down in the EUMR, but the transaction is of interest for other reasons, because it involves innovation, technology markets, i.e. so-called killer acquisitions, the European Commission still tries to apply its merger control regime. And in 2021, one of the things the European Commission did to do that is they published new guidelines with regard to a long forgotten referral rule, if you want to put it like that, i.e. with regard to Article 22 of the merger control regulation. It was already there, but in practice it was applied differently. And the European Commission looked at the wording and said, well, I can also apply it more broadly and proactively invite member states to refer transactions to me as the European Commission, even if transactions do not meet the national turnover threshold. So even if transactions are there that do not meet the EUMR thresholds, neither they meet the the national thresholds in the member states, this can still be referred to the European Commission for review. So ever since, as you may imagine, companies must fear that under this referral rule, a transaction can be referred and reviewed by the European Commission, even if no technical filing requirement exists. And that, of course, leads to uncertainty. And we are dealing here with technology transactions. So usually these transactions have a very high timing pressure. So the uncertainty is even more pressing and of more significance. And this goes even further under the DMA, and we will talk about these rules in comparison also to the Turkish rules in a short while. The European Commission can also require designated gatekeepers to inform them about transactions that these gatekeepers are doing in their markets, and then again use Article 22 EUMR to invite the member states that are dealing with these transactions to refer such a case under these referral rules to the European Commission for them to again review such a transaction without any filing requirements being triggered. And lastly, to finalize this overview, there is the Towercast decision that everyone might have heard about, where the European Commission again reinvented a long forgotten practice. Again, there was traditionally this practice already with regard to an ex post review of transactions. And this stems from a time where you did not have the EUMR in place. So in the 70s, there were cases where the European Commission used its dominance rules, which are older than the merger control rules, to look at transactions after they were implemented and to see if now there are dominance rules which leads to a need to change the transaction after it was implemented already. So the European Commission assessed these transactions basically under the dominance rules and after they were implemented. And in Towercast, which is a new decision, even if in a situation where we have merger control rules that provide for an ex ante review, so for a review before a transaction is implemented, the European Commission now again used this old practice and assessed the case after it was implemented under the market dominance rules. So these instruments are very creative in capturing what we call killer acquisitions or technology acquisitions.
Actually, in terms of technology undertaking exception, some people may say that the definition itself is broad. Some people may say that the interpretation is wider than expected. But at the end of the day, I see a legal definition. And compared to Article 22 enforcement, I should say that in terms of legal certainty, as a competition lawyer, I prefer a definition. What are the practical implications for companies in your view within the EU, or to deal with EU merger control regime under such circumstances?
I agree, Bahadir. So I think that the reforms in Turkey, of course, provide for some certainty, at least because they provide for a definition, while in the European Commission, there is no such clear definition of what is captured and what is not. And therefore, the implications are huge. So the European Commission is applying the merger control rules through the back door, if you want to put it like that. Companies in the old world were used to a world in which they could run an MJ analysis, which means a multi-jurisdictional analysis of merger control rules in different member states based on the turnover or other requirements that are there. And the result was either a filing is triggered or a filing is not triggered, and companies would rely on this assessment. It's a normal way how this was done. With the new rules that the European Commission is applying now, this certainty is gone. And even in a case where the thresholds in a member states are not met, so where you have as a result of your analysis clearly no filing required, the European Commission can still pick up this case and analyze it and review it under the merger control rules. One example where you can see the implications quite clearly is the Illumina Grail case. Here, the companies relied on their analysis. They saw no filing requirements and closed and implemented the transaction. The European Commission then applied the referral rule under Article 22, assessed, and eventually, and this is the worst case you can imagine, prohibited the transaction. So you have a done deal already implemented, which now has to be rewound. And we all have heard at some point the saying, you cannot unscramble scrambled eggs. It's very difficult for companies in practice, once they are integrated, to reintegrate again. That's the worst case scenario companies in transactions fear. Illumina was facing exactly this situation and was forced to divest Grail again. This decision was brought to court, understandably. It was upheld by the General Court and is now pending before the ECJ, which is expected with a lot of excitement, of course, what they will say. And the Towercast situation is actually similar. Again, the implications can be the very same. So in an ex post review situation, after implementation, you might fear, if you are a dominant company, or if you are deemed to be at least powerful in your market, that in a transaction that you did, you might be forced to rewound it, which, as I said, is really a nightmare for companies.
What can companies do then?
So the practice of the European Commission is understandably criticized, and it is difficult for companies to deal with these newly established instruments, as you may imagine. While some transactions, especially dealing with highly innovative markets, might be worthwhile to be discussed with the European Commission, even if no technical filing requirements exist, Article 22 is applicable to any sector. And that's what you said, Bahadir. There are no clear definitions, and it is impossible to foresee with absolute certainty whether or not the European Commission will show interest in a case or not. The danger of arbitrary referral requests is therefore high. It is there and existing. Companies must therefore assess in any transaction, if based on the practice of the European Commission so far, it could make sense to proactively approach the authority to discuss a potential filing requirement. And the same applies to Article 102, the dominance rules that are now applied in the Towercast decision. So companies that have a certain degree of market power, with or without clear dominance, should probably also approach the European Commission, especially in technology markets, before they acquire target companies, at least if there is a certain importance and a deal value that you could already imagine. Another interesting case I want to quickly mention in this regard is the Facebook customer case, because here, Article 22, the referral Article 22, led to even parallel merger control proceedings within the EU. disregarding the one-stop shop principle that we also all know. So as the German authority does not agree with the European Commission's interpretation of Article 22, they did not refer the case to the European Commission, what other member states did, but reviewed the case by applying their own rules. So because the European Commission was not originally competent to deal with the case, but only via a referral via Article 22, the German Bundeskartellamt still said, oh, I can also review this case because the one-stop shop principle technically does not apply here. And in this case, the companies had to face 2 merger control proceedings within the EU, which you would also think is not possible because of the clear division of competences. So this is also, again, a very important implication that companies have to have in mind when dealing with technology acquisitions, and looking at this practice that they have seen so far.
How do you feel then whether Turkish regime, this new regime, could be a role model for the EC?
So in my view, any reform that is out there and provides for a certain degree of certainty should be absolutely welcomed by companies. And the regime in Turkey at least seems to be clear in what it defines as captured technology acquisitions. And it has a clear list of sectors that are targeted. But I think it would still be interesting to understand if the reforms in Turkey actually, as they are applied in practice, provide for such certainty. So how is the number of cases that is brought to the competition authority? Has the number increased significantly and importantly? How many cases have been dealt with really under these rules? And is there in practice some further guidance that the authority provided that led to a little bit of more certainty? But in the end, I would think that the situation we have now in the European Commission with Article 22 referrals, Towercast, maybe even the DMA referrals that will come to us in the near future, lacks legal certainty, is not providing for enough certainty for companies, and reforms such in Turkey or maybe in other countries might be a good role model that should be thought about also at EU level.
Thanks a lot, Kaan.
Thank you. And I will now hand it to you, Hanna.
Thanks a lot, Kaan. So yeah, my turn, right, to talk about the last but not least important topic nowadays, the digitalization, and specifically the changes that are taking place in Turkey as well as worldwide. Topic relevant for any jurisdiction that we may think of today. In other words, we can describe the current situation as digital markets flow and legislation follows. I like saying it that way because indeed the law is always several steps behind the digital developments, and we all observing, we all following the news, we all understand that undergoing changes brought about by the emergence of new types of the abusers, for instance, right? The notorious self-preferencing in the EU as well as in Turkey, also currently available. The TCA came up also with the definition with its case law, the self-preferencing. So all in all, Turkey, like many other jurisdictions, is trying to catch up, or in other words, to keep a step with this flow of the digital markets and all the challenges that they bring. And trying to respond to such challenges by way of, well, first of all, updating its respective laws, by way of investigating digital markets more intensively, as well as by upgrading the institutional capacities and enhancing cooperation between such authorities as well as nationally and internationally. I believe this is all relevant to any jurisdiction nowadays. Well, since our focus today is Turkey, let me focus more on what's actually happening and what was happening in 2023, last year. And that's, let's call it Turkish DMA, even though it's not really DMA, because unlike the DMA, this is not a stand-alone legislation, no separate act. Turkish DMA is in the form of the amendments to the Turkish Competition Law, draft amendments as currently stands, and those amendments are expected to be adopted sometime this year. Well, we'll see how it goes. In essence, those draft amendments, they are very much inspired by the EU DMA, as well as the amendments to the German competition law. So kind of combination of both. Just to give you some sense of what is there on the plate. So the key areas that, let's say, potential gatekeepers should pay attention to is the designation process, the actual definition of the gatekeepers, procedure, enforcement, and of course the penalties. I repeat, this is still a draft. It's not yet enforced, but it's always nice to be prepared what may come into force soon. So if we look at those amendments, we see that there's no actual definition of the gatekeeper. Well, under the Turkish law, it's not a gatekeeper, it's called undertaking with a significant market power, which is kind of a gatekeeper because in essence it relates to an undertaking with a significant power and that provides one of the core platform services. And the whole process similar to the EU DMA, because there is a designation. There must be a designation decision. So if you are undertaking with a certain power, you believe, and you provide one of the core platform services, and you meet one of the criteria, either quantitative or qualitative, then following self-assessment, you are to notify the Turkish Competition Authority within the specified time. One point that I would like to emphasize here is that unlike in DMA, currently there are no quantitative criteria available. Why is that? Because TCA is still working, I guess, and will come up with a separate communique, with a separate guideline outlining that quantitative criteria. But from now, we already see that the approach is similar as in DMA because it will be based on the annual gross revenues, number of end users, and number of commercial users, or number of commercial users. So once following the self-assessment, you feel that you may be designated, you need to notify the Turkish Competition Authority. There are timelines within which you can do that together with any rebuttals, any objections that irrespective of meeting the criteria, you may still believe that you are not undertaking with a significant market power. Validity, the TCA is limited with a specific time frame within which to give to take the designation decision. The decision has a validity period, so it's 3 years. 3 years with the possibility to renew it unless there are changing circumstances and the party concerned notified the TCA within 90 days prior to the expiration of these three years. And in general, the designation decision compliance deadline or compliance with application deadline is 6 months. There are penalties. We're talking here, they are doubled actually. If we look at the current penalties available under the Turkish competition law, that's up to 10%, right? But under the proposed draft amendment, the penalty for non-compliance doubles to up to 20% of the annual worldwide turnover. Periodic payments are also possible, as well as certain other penalties for specific misconduct, let's call it. I would like to draw attention here to the notion of the systematic non-compliance. So it's also another power that the Turkish Competition Authority will have, the ability to ban, prohibit concentrations, mergers and acquisitions of such gatekeepers if they received minimum two infringement decisions within a period of 5 years. So then you're classified as a systematic non-compliant undertaking, and hence there's a risk that any possible transaction that you would like to implement within the period of future 5 years may be banned. So other than that, the enforcement powers also, the Turkish authority gets some additional enforcement powers in terms of requesting the undertakings concerned to comply with certain technical and administrative requirements in order to enable TCA to conduct on-spot inspections more effectively, so compliance with the technical administrative formalities.
Thanks a lot, Hanna. It's very interesting and exciting to see that you also draw comparisons to Germany, because as you might know, there is also some dispute between the the differences between the German situation and the situation in the EU with the DMA. But I think going into that detail would fill another webinar. So, but just in summary, so what are the main differences then between the Turkish anticipated regime and the DMA at EU level?
Thanks, Kaan. And Aaron, may I ask? Yeah, next slide. So I think it will be easier to kind of visualize these main differences. In fact, there are not many differences. As I already mentioned, so the amendments are very much inspired by the EU DMA and the German competition law amendments. So the main differences are spotted, well, in terms of terminology. I already identified this gatekeeper undertaking with a significant market power. Some very minor in scope of the obligations. I would say that under the Turkish draft amendment, some obligations are even wider in scope because due to their open-ended formulation, let's say. Right, and there are some nuances as well in relation to the sanctions. If we go one by one, so in terms of designation, more or less the processes are similar. The differences are in terms of the time frames, right? We see obligation to notify in the EU that should be done within 2 months, under the Turkish amendments within 30 days. Then European Commission to decide within 45 days of receiving complete file, while in Turkey that's within 60 days. Thresholds, as I mentioned already, so the biggest difference here in the DMA, they are in the actual text of it and currently available, while in Turkey it's still maybe under the construction kind of, right? And the new communique will come 6 months following the adoption of this amendments to the Turkish competition law. So good and bad, maybe positive and negative sides of this is that the companies a little bit uncertain what to expect, but on the other hand, they still have some time to kind of to prolong this process, right, of complying with the obligations under the EU amendments. What else? Some main differences: the validity of the decision. So this is different from what we have in the EU. Also kind of mentions here 3 years, but how is it different? In Turkey, we have decision is valid for 3 years, and then 90 days before, so basically 3 months before the expiration, if the company did not submit change in circumstances that would kind of cancel or change the destination decision, it automatically prolongs, right? Automatically renews for another term of 3 years. While in the EU, we see that the decision doesn't say the validity of decisions for this year, but it says that every 3 years, at least every 3 years, the Commission is to review the destination decision and the circumstances, and then to decide on the status of the company respectively. Plus obligation to publish updated list of the gatekeepers that the European Commission has. I haven't seen that one in the Turkish draft amendments yet. This another difference, systematic non-compliance, as I already identified under the Turkish amendments. In the EU, that's 3 non-compliance decisions within a period of 8 years. So different, but not that big difference, right? Fines, also some nuances in here we see, because in the EU, that's actually up to 10%. But of course, there's possibility to go further, higher, to up to 20% of the worldwide turnover in case of the repeated infringement. So Turkey, in this sense, seems to be stricter. Right? One more thing in relation to the systematic non-compliance is that TCA, under the Turkish law draft amendment, it says that TCA will have power to ban any concentration for up to a period of 5 years. So specifically, given for the 5 years, you will not be able to complete any transactions. In the EU, this is kind of a limited period, so may ban the concentration during a limited period. So what period is that? Nobody knows. I don't know, leaves kind of, again, some may see benefits, some may see advantages, disadvantages in this wording, but that's how it is right now. As for the enforcement, so the final part that I would like to mention, enforcement, I mean, under the DMA, it seems like more clarity as to there is a specific requirements for the gatekeepers to establish compliance function within the undertaking, kind of responsible council or responsible, not authority, a person for compliance with the DMA. Under the Turkish draft amendment, there is, I haven't seen such a requirement, but I guess this is due to the fact that it comes under the general amendments under the Turkish Competition Law, so general compliance with the Turkish Competition Law, so kind of general council, compliance council will be responsible for that. That's my assumption. And finally is that positive thing in the EU that they have a high-level group composed of the representatives of various authorities, including the data protection, some regulators, as well as European Competition Network. And I find it very useful because in such a way they can exchange advice and expertise in their respective sectors in order to make sure that there is no over-regulation maybe or no overlap. I haven't seen that directly in the amendments to the Turkish Competition Law, but there are other laws, or let's say the recently concluded cooperation protocol between the TCA and the Data Protection Authority also kind of serves a ground for more information exchange, more cooperation between two authorities, important one. So I see it as a positive development. All in all, major things are very much similar to the EU DMA with this minor differences that I outlined.
Thanks so much for this very helpful overview and comparison, Hanna. And linking it to the merger control topics we just discussed, are there also merger-specific provisions in the Turkish DMA, for example, like in the European DMA, an obligation to notify intended transactions if you are a gatekeeper?
Thank you so much, Kaan, for this. Actually, I forgot to mention this important difference between the DMA and the Turkish DMA. Indeed, there is no such requirement. So the widely criticized, in fact, provision under the DMA, this obligation to notify, for the gatekeepers to notify all intended concentrations, is this provision, this requirement is not present under the Turkish law. But we can explain it by the fact that in Turkey we have this technology undertaking exception that you covered. So yes, you do not have to actually notify every year all the intended planned transactions, but you have to be very careful with this technology undertaking exception, because you may be covered by it and you may required to notify, not just in terms of notification information purposes, but the actual merger notification has to be done. Yeah. So just if time allows me, I'll just want to maybe wrap it up by saying, so these are the things for my part that happened and have happened like last year, and we'll bring them to 2024 to this year. But to be more precise, like what's next, as the title of our session, right? So that's what happened and what's next. Well, for sure, the digitalization and digital markets will continue to be among the priority areas, enforcement areas of the Turkish Competition Authority. We may expect some clarifications in terms of these new infringements, digital market specific infringements that are taking place, like self-preferencing. Some developments, some new cases may appear as well. The main thing is that this is still in Turkey. This is still we're still at the stage of the draft amendments. Yes, there are rumors saying that those are expected to be adopted this year, but it may take longer. So maybe it's actually for better even. So in fact, maybe it's wiser even to wait and see the aftermath, the consequences of the DMA enforcement in the EU first. Why? Because we understand that DMA in general is a big experiment, but no one actually knows for sure how it may evolve. So irrespective of the adoption of those amendments in Turkey, the EU enforcement of the DMA will have an impact on Turkey and other non-EU jurisdictions. And in fact, such jurisdictions may take advantage, including Turkey, until we adopt those amendments, we may take advantage of the free riding, right? Since the subjects of the DMA and of the DMA rules are global operators. So hence the compliance with the DMA is likely to reshape behavior of the gatekeepers globally. That's one message that I would like to underline in here. And on another note, what to expect is probably more institutional changes caused by such amendments, because digitalization, innovation, they require that competition authorities kind of renew themselves to adopt to this technological changes, to the new types of the, as I mentioned, infringements, and the new ways to detect those infringements, right? So digitalization, innovation, the re-equipping, if I can say it that way, of the competition authorities. Yeah, but that's, I guess, the main message that I would like to wrap up my session with this message. Thank you very much.
Thanks, Anna. I also would like to add very briefly what is next in the labor field. The Turkish Competition Authority is working on a guideline in HR field. This is quite important. And this guidelines will definitely further clarify the authority's approach, for sure. Since labor field is one of the focus areas, we should expect more cases in Turkey. And this fact should also increase efforts in competition compliance work in HR field. This is also my last outcome in terms of HR field developments. Yeah.
As for merger control, I think we're also expecting new cases and to see the TCA's practical application of this technology undertaking exception, right? I think so.
Indeed, and it will be interesting to also see the developments in Turkey in this regard, because it indeed might be a helpful role model. And I think it's important for both jurisdictions, basically EU and Turkey, to see what the established practice of the authorities will be, to at least that the decisions and case law provides more guidance for the companies to have some more certainty in that regard.
Definitely.
Highly likely technology undertaking definition will increase the number of notified transactions because of the coverage of definition mainly. Definition covers software, gaming software, digital platforms, financial technologies, health technologies, agrochemicals, pharmacology, biotechnology. I assume that these listed areas represent more than 50% of current transactions in the technology related world. So yeah, we should expect more Turkey related notifications based on this definition, based on this exception.
Brilliant.
Well,
well, thank you. Well, we have a little bit of time for a Q&A section, but just before we move to that, I want to say thank you very much for your time and your insights today. It was incredibly interesting just listening in for the past hour. Now, usually at this point, I do ask for your sort of closing thoughts and if there's anything that you'd like to leave the audience with, but I think that that discussion you had at the end has sort of covered that a little bit. There have been two questions in from the audience. I can see, Bahadir, that you can see those. I don't know if there's perhaps one that you want to take now, just looking at the time. I think we should have time just for one of those questions.
Shall we take this question related to Constitutional Court decision? Okay.
Right. If I just read that out for the audience, what are the developments or changes you expect after the Constitutional Court's decision that a judge's decision is required for on-site examination?
Actually, it's quite complicated. It's quite complicated since we know that High State Council also referred to that matter to Supreme Court, to Constitutional Court, and in couple months, Constitutional Court will come up with a new decision. Actually, this new decision will be very decisive in terms of the new approach, in terms of the new enforcement. So without hearing from the Constitutional Court for this new judgment, it is quite difficult to comment on it.
Brilliant. Thank you very much, Bahadir. So to the person that sent that question in, if you do require any more information or would like to get in contact with the panel, we will be sharing all of our panel's contact information. And to everybody in the audience today, we do recommend you get in touch and reach out to our panel and reach out to the firm. They will be more than happy to have a conversation with you. So just looking at the time, I think that we will need to wrap up at that point. But once again, thank you very much to our panel, Bahadir, Kaan, and Hanna. Incredibly informative and I think a very important webinar today. To our audience, thank you very much for being with us. We really appreciate it. As I say, we will be sending a recording and the contact information over to you this week. So once again, thank you very much for joining us. Thank you to our panel. Wishing you a lovely rest of your day. Goodbye.
thank you. Thank you.
Thanks a lot, Jen.